On the 4th of March 2022, Kouri Richins was found dead by his wife, Kouri. Then just over a year later, Kouri was arrested and charged with Eric's murder. Stay tuned, and we're going to continue our coverage of this case. If you're new here, hi, my name's Katie, and this is where we discuss true crime, politics, and current affairs. So if that sounds like something you're interested in, make sure to subscribe. And if you're a returning viewer, you know how this goes. We go through a document, I give my uneducated, unsolicited opinions. So you might as well go ahead and like the video now, because you know you're going to like it. So let's see, what was it today? It was a witness declaration from Crystal Bowman Carter. So let me share my screen with you so you can see what I can see. This was from quite a while ago. Let me see if I can find the date. There we go. So this was June 2023. So what, 6 months ago-ish? So it was a while ago, but it is still relevant. So it is the Declaration of Crystal Bowman Carter. So my name is Crystal Bowman Carter, and I am a resident of Summit County, Utah. I am an attorney licensed and practicing in Utah. I have focused my practice almost exclusively in the area of estate planning since 2012. I first met Eric in or about July 2018 when he retained me to prepare a buy-sell agreement for his company C&E Stone Masonry LLC. The buy-sell agreement was to require a mandatory life insurance cross-purchase agreement between the surviving member of C&E Stone Masonry and C&E Stone Masonry LLC upon the death of one of its members. In assisting with the buy-sell agreement, Eric asked me to direct all questions about life insurance to his financial advisor, Brian Freckleton. If you are so legally minded, what's the difference between C&E Stone Masonry and C&E Stone Masonry LLC? Apart from the LLC, what difference does that make? Can someone explain to me in the comments? Thank you. Okay, so point number 3. Brian Freckleton told me, Bowman Carter, that New York Life Insurance Company had issued 2 life insurance policies, policy numbers, blah, 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 to Kouri M. Wright on the life of Eric Richins, each with a face value of $1 million. The buy-sell agreement was drafted to include those policies as part of the mandatory life insurance cross-purchase agreement. Eric retained Bowman Carter again on or about October 13th, 2020. At a meeting, we had to discuss his estate planning. At our meeting, he told me he had 2 primary goals. His first goal was to protect him in the short term from fairly recently discovered and ongoing abuse and misuse of his wife, Kouri Richins. So what? So October 2020. Eric was aware, allegedly, that Kouri was interfering in his finances. His second goal was to protect the 3 young sons he and Kouri had together in the long term by ensuring that Kouri would never be in a position to manage his property after his death. He indicated that he felt that designating someone other than Kouri to manage his property after his death would protect his sons from Kouri's poor financial choices and decisions. I don't think my eyebrows can get any higher right now. Hey. So he wanted to protect him in the short term because he alleged that Kouri was messing around with his finances. And secondly, he didn't even trust her to look after the kids financially because she has poor financial management. Oh, I mean, point 4 and my eyebrows are already like touching the ceiling. Awkward. Point 5. Eric stated that his fairly recent discovery of Kouri's ongoing abuse and misuse of his finances was what prompted him to seek my help. He disclosed that he had recently learned that Kouri had misused his power of attorney when she used her agency to obtain a $250,000 revolving line of credit secured by his separate property, the personal residence he and Kouri lived in, without his knowledge or permission. He stated that he had only learned of her misuse of the power of attorney when his ability to use some of his banking and credit accounts had been frozen. So she took out credit on their home without telling him, by the look of it, allegedly. Okay. At our October 13, 2020 meeting, Eric also provided me with a worksheet from my office that he had completed in advance upon my request to allow me to determine the composition and extent of his estate. In the life insurance section, he directed me in writing to ask Brian, who I knew to be Brian Freckleton. I was already aware of the 2 New York life insurance company policies totaling $2 million that were subject of the buy-sell agreement mentioned above, as in the business one. I followed up in conversation and asked Eric if there were any other life insurance policies I should be aware of, and this time he orally referred me to Brian. He told me that Brian Freckleton had all relevant information about his investments and any life insurance policies on his life, or of which he was the beneficiary. Eric expressed an urgent desire to complete his estate plan. He asked me to prepare the documents as quickly as I could. We scheduled November the 3rd, 2020, 3 weeks to the day after our October 13th, 2020 estate planning meeting to sign the documents. At Eric's request, I prepared, among other ancillary documents, a healthcare directive, durable power of attorney, pour-over will, and living trust, known as the trust, for Eric. In each of the estate planning instruments I drafted, Eric designated his sister, Kouri Richins Benson, followed by his father, Eugene Benson, to serve as his designated agent or fiduciary to the purposeful exclusion of Kouri. Eric made and requested several unusual or highly unusual choices and provisions to his estate plan. The first being, it has been my experience that it is highly unusual for a spouse to fail to designate their spouse as their healthcare agent, even when they do not want their spouse to manage their property in the case of their incapacity for whatever reason. In our first discussion, Eric told me he did not want Kouri to serve as his healthcare agent, which I noted on the intake worksheet he had provided. I cannot recall any other married client whose spouse was capable of making healthcare decisions for them, choosing someone other than their spouse to serve as their primary healthcare agent, except when divorce is contemplated. Eric was initially very clear that he did not want Kouri to have any healthcare decision-making authority and designated his sister, Kouri Richins Benson, followed by his father, Eugene Richins, to serve as his healthcare agent should he ever need one. I'm sure they've given Eric's dad 2 different surnames. Anyway, after sending him a draft of his healthcare agent, with Kouri listed as the primary healthcare agent, Eric changed his mind and asked me to insert Kouri as the primary healthcare agent ahead of Kouri. Okay, so you know the person that signs off the machine if you're on the machine. Initially, it was his sister, Kouri, and then if she couldn't do it, it was his dad. And then he changed his mind and changed it from his sister to his wife. Sure. Maybe they were contemplating divorce at that point when he made that decision. We don't know. Eric wanted to provide for Kouri as the mother of his children after his death, but wanted it to be very clear that must she benefit from the minimum amount he was required to leave her, and that she could not control either the share left for her benefit or the share left for the benefit of their children. As a result, I included a statement of intent in Eric's trust specifying that by creating his trust, Eric wished to provide for both my wife and our children during any time that I am incapacitated after my death, and to preserve and protect and pass as much of my property remaining after my death and that of my wife to my descendants. I rarely include a statement of intent in my revocable trust documents. Historically, I have only included statements of intent to capture the state of mind of the grantor at the time the trust is drafted and executed. I included a statement of intent in Eric's trust. Okay, so he wanted to leave her as little as he legally could, and that what she was left with, she didn't really have control over, and she didn't have control over the money that was left for the children. He really doesn't trust Kouri with money. Okay, next point. Eric chose his sister and his father as his successor trustees. I explained to Eric that the most common choice for the successor trustee of a married person's trust, when there is not a blended family, is that person's spouse. Eric told me that he did not trust Kouri to manage the property either wisely or for the benefit of their children if he was unable to manage that property. Instead of designating Kouri as his successor trustee in the event of incapacity or death, he designated his sister Kouri Richins to serve as his first successor trustee, followed by his father Eugene Richins as his alternate successor trustee. Eric asked that all of his tangible personal property, not distributed by a list called a personal property memorandum, that the terms of his trust allowed him to make after signing his trust, be distributed between his 3 minor sons in equal shares. This is highly unusual when the family is not a blended family and the children are young minors. The great majority of the times that I create a trust for a married person in a non-blended family relationship with minor children, the client asks me to require distribution of all tangible personal property not described in a personal property memorandum to the surviving spouse to do with as they decide. Right, okay, that one was a little bit legalese. But from what I understand, any property that hasn't been specifically described in the trust usually is left to the partner to do with what they will. Whereas this one has made damn sure that she don't get any of it. 2 days before Eric was to sign the estate planning document I had prepared for him, he provided me with a premarital agreement dated June the 15th, 2013, which I reviewed. Under this agreement, Kouri agreed that C&E Stonemasonry LLC was Eric's separate property prior to their contemplated marriage and would remain his separate property after his marriage, even if he contributed marital funds to the business. The premarital agreement purported to give Kouri a future interest in Eric's partnership interest in the business up on his death if they were married at the time of his death. Kouri agreed that she would relinquish her statutory right of election to take against Eric's interest in the business, except as otherwise stated in the agreement. So, the prenup says Kouri can have an interest in Eric's business when he died, but she agreed that she would relinquish her right to take Eric's interest in the business, except as otherwise stated in the agreement. Okay. So she can keep her interest if she has one, but she can't have his, I think. I explained to Eric that since the prenup did not attempt to address any property other than the business, a court might find that he could not entirely disinherit Kouri, even though that was the desire he expressed to me. I explained to Eric that even though the elective share that would be allocated to a trust for Kouri's benefit was more than he wanted to see passed to Kouri as a result of his death, At the very least, his sister Katie would control Kouri's trust share for Kouri's benefit, thereby ensuring Kouri could not waste it and also ensuring that if any assets remained in Kouri's share at the time of her death, those assets would then pass to their sons instead of someone else, such as one of Kouri's other family members or a future spouse or partner of Kouri's. Okay. So the prenup only addressed the business. So Eric couldn't entirely disinherit Kouri. And that anything that Kouri did get on her death would then go to their sons, rather than Kouri's new family should she get one. It was out of an abundance of caution that rather than disinheriting Kouri completely and risk her claiming an outright statutory share of Eric's estate at death, that Eric provided for Kouri at all in his estate planning. Oh, so if he didn't include her at all, she could go to the court, and because they were married, she could probably get at least something. Whereas if he made some provision for her, she'd get that, but nothing else. Even though the durable power of attorney I had prepared with Eric, signed on November 3rd, 2020, expressly revoked all pre-existing financial powers of attorney, Eric was worried that Kouri might continue to attempt to use the revoked power of attorney, which she had previously misused, to obtain that $250,000 revolving line of credit secured by his residence. I had prepared a revocation of that durable power of attorney for Eric to sign on 3rd November 2020, along with his other estate planning documents. It required Kouri's signature acknowledging the revocation. I planned to file the fully executed version with the Summit and was County Recorder's offices. I can't say that word. Eric declined to sign the revocation at that time. In 2020, I never spoke with Kouri, and she was not a party to any of my meetings or interactions with Eric. To my knowledge, Eric did not tell his wife he had retained me or that he was changing his estate plan. At some point during my 2020 representation of Eric, he asked me and my office to communicate with him directly by phone without leaving messages or to send emails to Katie, rather than to his email, because he was concerned that Kouri was accessing his phone and his email. Okay. That's a bit sneaky. You know, if it's true, Kouri's accessing his emails. February 16th, 2021, Eric signed a revised revocation of durable power of attorney, which did not require Kouri's signature, but did state that he had advised Kouri that he had revoked her authority to act as his attorney, in fact, under his May the 8th, 2013 durable power of attorney. Okay, so he took her off it and he said, yeah, I told her. Whether he did or not, we will never know. On the 5th of March, 2022, I, Bowman Carter, received a call from a Summit County Sheriff's deputy. The deputy asked me about Eric's estate plan and to explain its contents to Kouri over the phone, and handed the phone to someone else. I then explained to a person I believed to be Kouri and who identified herself as Kouri that I had drafted an estate plan at Eric's instruction that included a revocable living trust, which had become irrevocable as a result of his death. I explained that he had transferred his property, including the separate property home he had owned prior to their marriage, but that they had both been living in prior to his death, to his trust. So he's put the family home in the trust that she can't really sell, I don't think. I explained that Eric had told me that because she was the mother of his children and he wanted to provide for her in the event of his death, he had generously made provisions for her in his trust for Katie to manage up to 1/3 of his trust assets for Kouri's benefit, and that no one was going to force her to move out of Eric's house. Okay, so what, is Kouri still part of it? If Katie's only got 1/3? Kouri became extremely upset Her behaviour led me to believe that she was learning about Eric's trust and its provisions for the first time. Kouri shouted, "What's wrong with you people?" and "How could you do this to me?" and "This is my house." I explained to her that the trust owned the house and told her it's not your house. Oh, and then I declare under penalty, under the law that Utah that the foregoing is true and correct. Signed, Crystal Bevan Carter, the 8th of June 2023. It's just that last line. I explained to her that the trust owned the house and told her it's not your house. That's cold. If you have heard screaming throughout this video, I do apologise. It's one of my cats, Yogi Bear. He's getting hungry, even though he's not going to be fed for another hour and a half. But he is deaf, so he no longer meows, he now screams. So this is the declaration of Crystal Bowman Carter. And she did Eric's will, for want of a better word, trust agreement, etc. She wrote it all up. She's explained what Eric asked for. There is the argument that Kouri allegedly killed Eric to get the money. So if that's the argument, so she didn't know that the trust had changed. Therefore, she assumed that she would benefit from his death should he die. And if it's true that she's bad with money, maybe she's in debt and wanted the money to clear her debt. But there are also rumours of various affairs and other financial things, etc. So there's all sorts of reasons why she could have done it, allegedly. But I would like to remind everyone that right now, she is presumed innocent. She is currently sat in jail. She was denied bail based on the seriousness of the crime. And we still do not have a trial date. Some documents have been ordered to be handed over to the prosecution, but the defence need to come back with their reasoning as to why said documents should not be handed over to the prosecution. That's what we're waiting for now. Should be anytime soon. But there's also a document floating around the internet which I'm not sure if I want to cover it or not, because I don't know how reliable it is. So I don't think I will. Some people say it's from Kouri's friend, allegedly. So I don't know. I'm going to look into that. If you hear more about it from me, then it's because I looked into it. If you don't hear about it, then it's because I'm still not sure. But if you are interested in this case, what's your matter? Sorry, she's looking at me like with those big cute eyes. If you are interested in this case, if you are as obsessed as I am, please like the video. It helps with the channel, and subscribe to the channel so you never miss an upload. I try and do a Kouri episode every week on a Thursday, 8 p.m. UK time. I try. My illnesses sometimes prevent me from doing that, but we try. And then on probably a Saturday evening, I do a roundup of the weekly news headlines, which is all sorts of topics, including true crime. And then there's a spattering of other things throughout the week. So if you like the sound of that, please like, comment, subscribe. Let me know if... Stop it. Being too cute. Let me know if what you've heard today has changed any opinion of yours regarding this case. Please be mindful that there are children involved in the case as well, and that Kouri is currently presumed innocent. Leave me a like, even if it was just for this little ball of fluff. Say hello. She's just so cute. Okay, I'm going to go. Thank you very much for your company, and I will see you in the next video. Bye.